The next conversation we want to have is on impeachments, okay? So recently we were treated to a revision of the drama in the Senate.
Reoccurrence.
The recurrence of the drama in the Senate with the second round impeachment of Governor of Meru County, Kawira Mwangaza. Okay? And we saw what was presented by the county assembly. We talked to some of the representatives of the county assembly even before the matter went to the Senate. We saw what was being presented in the Senate. One of the advocates that was in the team that was for Kawira Mwangaza is Elisha Ongoya. He is an advocate of the High Court of Kenya and a senior lecturer at Kabarak University. He's our guest. Good morning, Okili.
Morning, Eric. How are you?
Very well.
Yes.
Welcome to Kenya's hot seat.
Thank you so much.
Now, City has the day's proverb, and this week's proverbs are from
Namibia. Yes. The Republic of Namibia.
Please remind us the name of the president.
The name of the president, he's called Hage Geingob. Now, I am reading it as it is written. If he is called Hage, that is okay, but it's written Hage.
Hage Geingob.
Yes, Geingob is written Geingob, Geingob. Can't pronounce it any other way. If there's another way it's pronounced, I will be informed, but I'm reading as it is. Then he has a vice president. It's called Nangolo. Why are you guys sniggering? So why don't you let me read the name?
Go on.
Please, carry on.
Okay? Mbumba. Mbumba. Bumba. Then you have the Prime Minister, Nangolo, that's the VP. Prime Minister is called Sarah Kavunagelwa.
Right.
Okay. Then you also have
The Chief Justice.
No, the deputy Prime Minister.
There's a
Chief
deputy.
Yes, the Deputy Prime Minister is called Metumbo Nandi. Simple, straightforward name. Then you have the Chief Justice. Now him, simple, straightforward name. It's called Peter Sivute.
You see?
Okay? None of these heavy-duty African names with alliterations. Just Peter Sivute.
The law is very clear.
Yes.
What's the proverb then?
The proverb is a little rain each day will fill the rivers to overflowing.
Okay, what's the proverb?
The proverb, this is what happens
When it rains.
The proverb for today is a little rain will fill the rivers to overflow.
A little rain will fill the rivers.
Each day. Just
A
each
little
day.
rain each day
will fill the rivers to overflowing.
overflowing.
Okay.
Wakili Elisha, what's your interpretation of this proverb? I mean, it sounds pretty obvious, doesn't it?
You know, one of the things I fear the most was that I'll be asked to interpret a proverb because I have never interpreted proverbs in my lifetime. But it would be the equivalent of what the Swahili say, haba na haba hujaza kibaba.
See? A man who interprets proverbs so accurately is afraid to interpret proverbs. Surely. As you put it, the law is simple.
It's very clear.
Very clear.
Very clear.
It's very, very clear. Wakili, we saw you on our TV sets and you were in the Senate. For whom were you acting?
Well, I was doing what I do for a living.
Teaching.
I keep reminding everybody that, I don't roast maize on the roadside for a living. I do precisely that. Not in a cleaner job. It's actually a dirtier job than any other job you can imagine. But I was privileged to be retained by Kawira Mwangaza's legal team to lead them in prosecuting her case.
To lead the legal team.
Yeah, to lead the legal team.
What does that mean?
There's a way the profession works. Legal profession is that different people have different specializations, like another profession, of course. And therefore, there is a moment when you can call on a lawyer of particular seniority to lead you in a particular case or in a particular aspect of a particular case. So, courtesy of my years of investment in constitutional litigation and considering the constitutional attributes in impeachment process, I was called upon to lead the legal team. The legal team had 8 lawyers and 1 legal assistant. So I was called in to lead these 7 lawyers and 1 legal assistant. So I was the lead counsel in that matter. Yes.
Have you participated in a previous impeachment?
No. This was the first impeachment. There have been 14 impeachments of governors in this country. This is the 14th, actually. since the inception of the Constitution of Kenya 2010. So I haven't been in the other 13. So I was in the 14th.
So finally, you got the chance to actually now test this part of the Constitution.
Yes, it's an area I have researched in, I have
course.
written on. So I guess that's partly why I was consulted in the matter. It's an area I've taught on, I have researched on, I have done presentations on in other events. So I guess that's how I was called upon to play.
Did your research much experience? The experience of it all?
I guess there's no point when research completely matches experience. Research helps in testing the experience, but there's no point in time when research completely matches experience. Young people teach me all the ground that reality that on the ground things are different. So the experience is on the ground. But we thank God that at the end of it all, our argument prevailed. Yes.
What's your outlook? Let's look at impeachment as an overarching principle in the country today. On one side of it, it would look as though it's being used as a tool for political conflict. On the other side, safeguard of the Constitution to make sure that individuals don't go into excesses. How do you see it being practiced or coming to life in Kenya today, before we get into the details?
To understand impeachment, you must understand power generally. When I was a young university student, I was taught law by Professor J.B. Ojwang. And those were the days when people were clamoring for the removal of the KANU establishment and the Moi regime. And Professor Ojwang was a fairly, if I may, conservative jurist. He used to tell, people used to say, let's amend the constitution, let's reduce presidential power. And he told us oftentimes that this is a very simplistic argument. Every time you give somebody functions, you must give that person power to perform those functions. So that the clamor for reduced presidential power as if it's an end in itself is naive. That power must vest somewhere. You can't remove power and throw it into the ocean. That power must vest somewhere. And power can be abused wherever vested. The fact that you are removing it from the president does not immunize it from abuse. Wherever you will vest it, it can be abused there. And therefore, he advocated for a more wholesome view of how we look at power. That if you disperse power, you must disperse functions as well, because power can't be allowed to idle. Number two, is also the nature of power that it must be exercised by human beings. And all the philosophers taught us that if governments were run by angels, if all men were angels, then there will be no need for government. We need government because men are not angels. Sadly, it is those men who are not angels who constitute government. And that's the obscenity of the whole situation. And government therefore becomes what we call a necessary evil. Government is actually essentially an evil. But that evil is necessary. Because if you allow human beings to run their affairs without this evil, then the outcome will be tragic.
More evil will prevail.
So impeachment must be viewed in that context, that we have reached a situation in human relations where we have agreed that power must check power. When you vest power in a particular office, you must vest another power to check this power. Only power checks power. So a number of things have happened in our design of the Constitution. We have created offices and vested those offices with certain immunities and certain powers. For example, we established the office of judge. And we say the nature of the work of a judge is that it must be conducted without external interference. So how do you guarantee this? One of the things you do is to give that judge security of tenure. We tell you do what you have got to do because you are guaranteed your term of office up to the time you get 74 years. But then you realize that this judge is not an angel. He or she too can abuse power. So you qualify that guarantee. You tell that judge, you have security of tenure, but security of tenure during good behavior. So that you have secure good behavior tenure. And so we also elect the president and say, no, you are guaranteed a term of 5 years once elected, with a possibility of renewal for further 5 years. But again, this 5 years is guaranteed subject to good behavior. Then a question arises, what do we do in the event of bad behavior? you must provide a remedy. If you provide a right without a remedy, then that right is hollow. So the remedy in this circumstance, say, look, the process of getting a governor or a president in office is through popular mandate. But the economics of popular mandate is too expensive. By the time you go to elections and get somebody into office, is an extremely costly affair. So if removing them has to go through the same process, it is not sustainable. Ideally, that's the way it should be. Ideally, if we are living in a perfect space, then to remove this person, we possibly have to go through the same process. But you can imagine the cost implications. It's actually unsustainable. So we go for the second better alternative through use of delegated mandate. To say, this popular mandate that we exercise gives us delegates, members of parliament, senators, MCA. So we can now use delegated sovereignty to exercise this removal from office. So that is the way in which this power is checked, the power of the governor through the impeachment process. There are multiple other prescriptions in the law for checking the powers of governors, the executive functions of governors. But impeachment is just one of them. It's actually the ultimate. It must be used as a last resort.
It's a last resort.
Because there are other lesser restrictive measures that I will allude to in the course of this conversation. So this is a last resort. When you are completely incorrigible, then we remove you from office. Otherwise, as I've said, there are other methods that we can check the governor.
Let's go to those ones.
Yes. One, you know very well that we go to court every day and challenge presidential actions.
Yes.
So we don't remove the president. You appoint somebody, we just go to court and quash that appointment. And that's it. You just remain in office, but your appointee has been removed. That's a method of checking you. We have power. The power of the judiciary has checked presidential power, has checked the governor's power. Parliament makes laws. We just go to court and nullify them for being unconstitutional. We have checked parliament's power. We have not recalled parliamentarians. So this is one. Number two, you know that the governor needs resources to run his or her government. And to get these resources, you must get approval of these resources by the county assembly through the budget process. So that's another way. You can just refuse to approve the budget if you discover that the manner in which the resources are being appropriated is not consistent with the aspirations of the county in question. Number three, you have things such as the Auditor General periodically comes and just audits the books of accounts of the county, and by law, the Auditor General must submit their reports of county audits to the county assembly and the national parliament, all of them without exception. So that's another way. You have the controller of budget. The controller of budget must check the manner in which resources are removed from the county revenue fund. Before you use the budget, this withdrawal of money, this use of this money for paying salaries and so forth must be approved by the controller of budget. So these are methods through which power is checked that are lesser restrictive. By the time you go to removing somebody from office, this person must be incorrigible. And this is the case we made before the Senate. That if I came to this studio and wanted to nitpick, I would find errors this morning, just from the things you have done here. I'll find that there are protocols laid down by this organization that if I were technical, I'll pick one or two that you have already breached. That's not a ground for removing you from office. There could be just internal memos that can be circulated here to tell you how we can do things better. Or just peer meetings among yourselves to review each other after this meeting to say, no, tomorrow we are going to do things differently. By the time we come to terminating your services here, you must be incorrigible. That's the point that we are making. So we, as the governor's team, didn't think that the assembly had proved incorrigibility. Fortunately for us, the Senate agreed with us.
Wakil,
Yes.
I like this word.
Yes.
Incorrigible.
Yes.
What is it?
You are beyond repair by the conventional, lesser restrictive methods. You can't be repaired by those ones. You have shown
put it in Lake Kiswahili kwisha wewe.
Sasa wesaidiwa. Wewe enda nyumbani.
So then, based on that,
Yes.
are you essentially saying that the motions of impeachment that we've seen wielded, the last 14,
Yes.
then essentially is akin to using a sledgehammer to kill a mosquito?
Out of the 14 impeachments that have reached the Senate, we're talking about that that have reached the Senate. The ones that have been attempted at county government level, I think I lost count.
Yeah, there are quite a number.
Yeah, there are quite a number. I suspect every county assembly throws some impeachment threat at a governor at some point in time. But the ones that have reached Senate were 14. Out of those 14, only 3 have been approved by Senate. 11 have not been approved by Senate. They have failed the standard. There are other perspectives I will reflect on as we get along. But we discovered Senate has two options when you present an impeachment motion before it. One, it can subject the matter to an investigation by an 11-member committee.
Yeah.
Or two, it can investigate the matter as a whole house. Before Kawira, there had been 13 impeachment attempts at Senate. Out of those 13, 3 had been considered by the whole house, and 10 had been sent to the committees. All the 10 that were sent to the committee stage never saw the light of day. They were disapproved. The 3 that had been considered by the whole house had been approved, which is why we were a bit apprehensive. You know, those of you who are soccer fans, you know, statistics count. When the Senate approved a consideration by the whole house, of course, that statistic was against the governor because of previous history. But again, as a person in the position I occupied, is you marshal your team and tell them, you know what, we have a role to play. Our role is to make the best case possible out of the situation. Then the decision maker is somebody else.
Never give up.
Never give up.
However, this body called the Senate, all right, as it's getting the report from the county assembly and being told this is what the county assembly has brought forth as charges for impeaching a certain governor, what is their role? Is theirs just simply a political role, or do they have some legal mandate?
Yes. Fortunately for us, a number of matters involving impeachments of governors have found their way through the courts. And now our courts, by design of our constitution, are the ultimate interpreters of the constitution. The ultimate. All of us are interpreters of the constitution, even you. As you sit here, you look at Article 34 and say, there is something called media rights. What are my rights within this framework? You are interpreting it, but your interpretation is not ultimate. The ultimate interpretation is that given by the court. So courts have given us guidance on this matter. The role of the Senate is quasi-judicial. It's judicial. So the Senate is a trial forum. It's a forum where you go for a hearing, and the Senate is supposed to apply its mind to a constitutionally prescribed criteria that the charges must pass a particular threshold before the Senate approves them. Now, Senate can approve charges that don't pass that criteria. Just like any power user or person vested with power can abuse power. But the advantage we have is that the decision of the Senate is itself subject to judicial review. You can carry it to court and ask, Senate has said this ground passed this threshold. Was Senate right or wrong in making that determination? And sometimes courts agree and set aside or quash Senate's approval.
But then you see, when a matter is before court, the judicial officer will have to justify the reason for holding or disapproving what's been brought before them. Senate doesn't have that. It appears the Senate only has to vote. And the individual votes of the Senate don't have to come with a reason. I don't have to explain why I'm saying yes to impeach or no.
Correct. There are two. Well, that's partly correct. What you've said is partly correct. It's partly wrong. If Senate resolves to take the impeachment trial to an 11-member committee, the committee must generate a committee report. A report must have reasons. So that's why a lot of us who control this prefer the committee way, because there's a report, there's something you can look at and say, well, here I think they understood me, here they got me wrong. When it goes through plenary, there is no opportunity for a report. There is a vote. But even when there is a vote, there is an assumption that that vote is based on the logic, on the grounds advanced, on the evidence in support of those grounds, and also taking into account on the objections to those grounds and the evidence in support of the defense against those grounds. Yes.
There is a document we keep hearing called the Hansard.
Yes.
What does it do exactly?
A Hansard is just a verbatim record of what happens in Senate.
So now, can that record not be used to cobble up a report?
You know, at the end of it all, once the vote is taken, there's no report in the sense in which I'm referring to a report. You know, when a committee prepares a report, it's an actual document called a report.
Yeah.
But
is the report not a factor of the deliberations.
It is.
Yes. And there's an analysis and then some conclusion.
Yes.
But when people vote,
Yes.
is that vote not a conclusion of the deliberations?
Well, when the speaker reads count one in the full sitting of Senate, as happened in Kawira's case, people go onto their machines and pass a vote.
Yep.
No one in their vote says, I am voting because I'm convinced by this argument that Ongoya made. They just vote. Unlike in the committee way, where people will say, we received the following arguments for. We received the following arguments against. We believed this argument for the following reason. So that's the report that I'm talking about. So technically, yes.
But
the Hansard,
before the depressing of that button,
yes,
whether it's red, green, or yellow,
There's some debate.
Thank you.
Yes,
but not by every member.
Yes.
But it is by choice. Are members prohibited from proferring an opinion?
They are not. They are not prohibited in the sense in which you use it, but because of time constraints, they could be. There are people who can
You may not
complaining.
catch the speaker's eye.
Yes, that's it. Or even if you catch the speaker's eye, but there are so many people because nowadays it's technology, and he picks the first 5, and the rest of the 42 of you didn't get a chance. That's as far as it goes. Unlike the committee where you actually retreat. You are booked somewhere where you deliberate. Your only business to deliberate, where everybody will have their voice heard. You generate a draft report. People reread it to confirm that, no, we can correct there and so forth. Up to the time they come up with a formal report. So I still suggest that we need to reconsider. Yes.
Allow me.
Yes.
Forgive me. I keep interrupting you.
Yes.
This time that isn't enough.
Yes.
How can it be increased? Because we were saying there's only time for 5.
Yes.
Can we increase this time so that at least...
We can. If you followed my final submissions in Kawira Mwangaza's case, I proposed a reform of the rules of the House so that we have more time. First, that time is there in the standing orders of the House, and Parliament can amend the standing orders at a point in time. Number 2, the advantage we have is that we have now tested this thing. You know, when you make rules in abstract, you may think 2 days, 3 days are adequate. This time round, by the way, things were made worse. We were supposed to have 3 days before Senate. On the 3rd day, coincided with the President's address to the Joint of Parliament. So it was removed. So what we were supposed to do in 3 days was squeezed in 2 days. Now, again, you see, those are circumstances beyond your control. They just coincided with the 2 events. And they are both important events. The law prescribes from the time the impeachment by the county assembly happens, the flow of events up to the time the Senate finishes its proceedings. On the other hand, the Constitution provides the President's address to the joint sitting of Parliament, and the 2 coincided. And therefore, they had to remove 1 day. And therefore, that time can be increased by parliamentary interventions. We are hoping that the senators who are directly affected because their voice was not heard are in a vantage position to propose amendments to the standing orders of the House so that time is enhanced. We're also hoping that those of us, I sitting here, one of them, you'll exercise our power to petition Parliament and say, look, we have now tested this process of yours and it's punitive. Let us see how we can enhance this
how else we can do this.
Yes.
Okay, there are several things that you've said this morning, more than once.
Yes.
We have tested this thing.
Yes.
We have tasted this thing. And now maybe it's about time we start having a conversation about what's our experience now with the impeachment process. And also you talked about, it's power versus function and safeguarding those things by having systems of checks and balances. Let me begin by asking, because we've heard this several times from several quarters, do you think county assemblies are abusing their power or have gotten to a point where there have been instances of abusing their power to check the county executive through impeachment?
Yes. There's an old French philosopher called Baron de Montesquieu who taught us that constant experience teaches us that every person vested with power is apt to abuse that power and to carry on with that abuse until they are met with checks. And therefore, it's not unusual for me to say that, yes, in certain circumstances, county assemblies have abused their power to impeach governors. And how the justification is not hard to come by, because if out of 14 attempts that have reached Senate, only 3 have gone through, what does that tell us about what Senate's own view has been over the manner in which county assemblies have used that power in the 11 or so other attempts? And remember, I'm not talking about those that have not reached Senate. We know, even from just media reports, there are many circumstances where members of county assemblies tell governors that you either give us this or else we remove you. Now, the power of impeachment was never meant to be used as a tool of bargain by county assembly for anything. Why do I say this? The Constitution specifies the grounds for impeachment. Specifies. Says there must be gross violation of the Constitution. Okay. There must be serious reason to believe that the governor has committed a crime under national or international law. There must be abuse of office or gross misconduct, or the governors must be laboring under such physical and mental infirmity that he is now incapable of discharging the functions of office. Those are the only grounds that the Constitution recognizes. Now, I have posed this question before. I'll pose it here. Why not just violation of the Constitution? Why not just reason to believe that the governor has committed a crime? Why does the lawmaker or the drafter insist on gross violation of the Constitution? Gross misconduct. Why not just misconduct? It tells you that the framer of the law begins by appreciating that to assume the office of governor, to go to that office, is serious business. First, it is exercise of the people's sovereignty as specified in Article 1 of the Constitution. And that exercise of people's power should not be easily interfered with by delegates. So that if a delegate has to step in, and by delegates I mean members of the Senate and members of county assemblies who exercise delegated power from the people, it must be a higher threshold, because they are undoing an act of the people, a sovereign act. It should not be done easily. So if you come across circumstances where members of county assemblies say, we are broke, and we want you, the governor, to give us a retreat so that we can get per diems. Then the governor says, no, I have no money for a retreat. Then we are going to impeach you. that clearly is never the intention of the drafter of this law. And where those kind of things have happened, that clearly has been abuse. Does that make this power unnecessary? No. The power remains innocent. The power is an important safeguard in our constitutional architecture. So the power must remain. But I keep reminding Kenyans this, and I'll remind you in this studio and other Kenyans out there, that the law is not an answer to all our problems.
No?
The answer to a bulk of our problems just lies in good manners. Let's just also get good-mannered people in the correct spaces. Life will be more palatable.
Well, that's interesting that you say that.
Yes.
Because members of the county assembly then would argue, and not just in the case of Meru, but other parts where an impeachment motion then has been suggested or preferred, that these bad manners that you speak of then comes out in full glow, public display, and it is for that reason that they feel it would then meet the threshold then envisaged by the Constitution. Does that play a role? Because if we're talking about the law and we're talking about just good behavior, good behavior, or that office demands a threshold for good behavior.
Correct.
And for them, they see, well, the behavior then that you exhibit is not what that position has demanded over and over and over again.
Correct.
And then because of that, we see no option but to then suggest a motion for impeachment.
That's exactly what the Constitution anticipates. Constitution says if you are ill-mannered and your ill manners become egregious, then they reach the level of gross violation of the Constitution, gross misconduct. So that's what the law anticipates, actually. But in these circumstances where people are using it as a bargain, it is actually those bargainers who are ill-mannered. Then they say, okay, we are going to clothe our ill manners by an aura of constitutional argument and say you have abused office,
Grossly.
or you have grossly violated the Constitution, and we are going to impeach you. Now, that is abuse of power on the part of those who are carrying out the impeachment. So I make an important argument here that the impeachment power is an important power in our legal design. It's important. Members of county assemblies, the Senate must retain this power. We can rework the way it is exercised for efficiency purposes and so that it's not abused. But the fact of this power, the essence of this power is not impeachable, it's not questionable.
It is an important power.
It's an important power. The only thing we need to constantly be on the lookout for is potential abuse of this power. There's something those of us who teach constitutional law insist to our students, that in a democracy, the law, what the law provides in its text is just an architectural plan. An architectural plan is not a building. However beautiful it looks, it's actually useless in itself. It's just a piece of paper. The real guarantee of the ambience that this architectural plan provides is something we call eternal vigilance. The people's consistent being on the lookout so that they guard against that abuse. That is the guarantee. That is the real bond that the people have for good governance and good government. So, yes, just to come back to your question, there have been instances when members of county assemblies have abused this power. Fortunately, because of the two-tier impeachment process, where the county assembly has to approve the motion and then the Senate has to relook at it, there has been checking power, which is what I told you earlier.
Is it fortunate or unfortunate? Because there are those that would argue that then also the Senate has abused its power and privilege.
Yes.
By just completely disregarding any form of logical argument that's been brought before it, and just going by political decisions.
Certainly, there have been
or other inducements.
Yes, there have been those instances. I mean, I have reviewed, in the preparation for this case, I reviewed the impeachment process for a gentleman called Waititu. You may like him or hate him, but I can assure you that if you subject his impeachment to a rigorous scrutiny, there is more than meets the eye. You look at it and you keep saying, I've invested quite a bit of years in studying this branch of learning, and therefore when I subject to that test, it's not a casual subjection I'm giving it. You may dislike Waititu for other reasons or other grounds out there, but I'm talking about the case that was presented to Senate. Look at this case and say this case on this ground was approved, then you begin having question marks about the manner in which that power is abused. Anyone can abuse power. I began by pointing this out to you, the lessons I gathered from Professor J.B. Ojuang, that this thing of saying, no, let's remove power from this office is naive. Wherever you vest that power can be abused there. And even the ultimate office, even when you say, the manner in which Senate does this can be challenged in court, even that court can abuse power. Then, of course, then there's an appellate process. The High Court can abuse it. Then you appeal to the Court of Appeal. It can abuse it. But then there's the Supreme Court that is final.
Can they also abuse it?
Yes, they can abuse power. They can abuse power. There are scholars who have reviewed our Supreme Court and concluded that it has abused power multiple times. And it's just the nature of human power. That's why I suggested to you people, there's no substitute for good manners.
Good manners is the ultimate.
Yes, the ultimate is finally mama alikuambia tabia mbaya. Jana tabia mbaya. That one is, we must also reflect on that for a while. I have argued that this country is in dire need of good manners more than strict adherence to the rule of law in and of itself.
It's a conversation we'll be having in the next hour with the chairman of the Ethics and Anti-Corruption Commission. Ethics and Values. Now, there are some governors and even legislators who have proposed an amendment to the way we approach impeachment. Some of them have said, let's safeguard a governor to come into office. First of all, learn the heretofores of the office. I mean, and just get to understand this office. So don't impeach a governor before a certain time is over. And then also look, towards an election, why are you impeaching a governor? Now, surely a deputy governor will come in and maybe they'll run this office for 6 months. So also, before an election, let's also have a safeguarded window, this and that. What's your view on this?
Law reform is a very strange thing. Anyone who believes that the guarantee for better life is more law is naive. I've told people that. What do I do if I elect a governor today and we say you can't impeach him in the first 6 months? Then he goes to the marketplace with a firearm and begins shooting everybody. What do we do with him? Day 2 in office.
Yeah.
We will begin crying that we need a formula to remove this fellow from office. Day 2 in office. So that whereas a lawmaker sees one aspect of the problem once it is tested and sees it clearly, sometimes they forget that by looking at you as I'm looking at you, I have turned my eyes against the backside of my head. I'm not seeing another facet of the same problem.
Yeah.
And when that other facet presents itself, you say, good gracious, we thought we knew what the problem was. We turned our eye against the worst part of that problem. My take is not that we immunize a governor who is 1 day office from impeachment or who is 1 month office from impeachment. Is that we use the impeachment hour correctly, whether it's day 1 or on the last day. If we did that, all these fears would go. If a member of the county assembly can misuse impeachment power when a governor is 2 months old in office, nothing stops him from misusing that power when a governor is 2 years old in office, assuming that you open up the window after 2 years. So the real recourse is dealing with this abuse of the power, rather than saying, no, if we insulate them for the first 6 months or the first 1 year, then so what? The abuse of that power will start once you open the gates after the lapse of that 1 year, and that is not very beneficial. I insist, there's no substitute for good manners.
For good manners.
We elect our governors, we elect our MCS, our MPs to exercise power correctly. More often than not, they honor that requirement in breach.
So there's something you're not saying, Elisha. So in these cases, the argument is not whether or not this individual did the thing that they have been accused of. That's not the argument. The argument here is whether these charges met the threshold then, and whether this impeachment as a power then is being abused. It is not whether there is a case on whether the road was named after whom, because these are the things that were brought. It is not whether indeed money was lost or not. You're not arguing that, because that could be a totally different thing if it actually did happen. What you're saying is that this is the measure. It has not reached here, and it should not be at this impeachment process. If those things did take place, use other avenues to challenge that. But this impeachment, again, coming to the fact that it's being abused for what it can actually do. Because I think there's a confusion there, that we seem to say, well, if it is alleged that somebody has done 1, 2, 3, up until 7, that was a number of counts. The fear is that, okay, how are we ever going to get this person possibly charged and or punished for this thing? We take it to impeachment, and then there's Elisha Ongoya who's saying, well, that's great, but you've not met the threshold, so everybody pack your bags and go. You see?
Yes. The argument is both. In some circumstances, there are allegations that are just plainly false. I mean, you remember I made an argument in Senate that, when you say I've named a road after Okoh, take me to Nairobi and say, a road is something physical. A road is not in the mind. A road is not abstract. Yes, take us to the road and tell us this road that starts from Standard Group to Panari is now called Okoh. Take us that road. Don't tell us that somebody put some mischievous post on her Facebook post. I mean, that's elevating jokes to new heights, if you sought my opinion. A road is just a road. We can't engage Senate on what people talked about their spouses on their social media posts. People say all sorts of things about their spouse on their social media posts. If you engage with those ones, the world will come to a close. So that's number one. Then the second one is, on the other occasions, is let's meet the threshold. For example, you take me through the accounts of this organization. Then you say, no, there's a voucher system, an impress system here. The voucher must be signed by everybody. Oh, one of these vouchers is not signed by somebody. Well, there's a procedure of surcharge. I can just surcharge you for this money and we clear this. In fact, the Public Finance Management Act is very clear on if you don't account for an imprest, we just surcharge you in the next month.
Payback.
So that unless there is complete pilferage, that you can see a systemic pilferage, the fact that there is one imprest unaccounted for, if you walk through government and you say for every department where there is an imprest not accounted for,
the thing will shut
somebody
down.
Must go home. Everyone will go home. The nature of an accounting system is, I've never come across an auditor who audits any department and does not find something that you can raise a question on. So that's what I'm saying, that if we were to pick a simple imprest and say, no, there's an imprest here that has not been accounted for, it's simple. Go and surcharge that person. their next month's salary, clamp something out of it, refund it to government.
But then it becomes gross and a serious issue if it is multiple cases.
If it's multiple cases.
Right.
If it is multiple, then that is something. Or if there are persistent audit queries along that line, that the auditor came here this year, raised this question, came the following year, same question, same department, no action is being taken, then that may approximate or reach the level of gross misconduct.
It is back.
You know, I'm listening to what I'm referring to as this legal presentation, and it's actually very interesting because now, at least on this matter of impeachment, we've actually addressed the law regarding impeachment. Not what somebody thinks, not what they would like, not even, and what they presented, yes, but through the lenses and through the microscope of what the law actually says about these things. But the thing that I like the most is the law in and of itself, without the practice and the vigilant observation of its practice, then it's exactly of no use to us.
Correct.
Because when we are not vigilant, it's like we ourselves are colluding with the forces that are bent on ensuring that law doesn't do what it's intended to do. So what that means then, Wakili, that is next to impossible to impeach a governor.
No. We have impeached Governor Waititu. We have impeached Governor Sonko. Governor Wambora was impeached twice. Only the court saved him. He survived by Governor Wambora needs to be studied as a phenomenon. It needs to be studied.
Case study.
Yeah, it's a case study. So it's possible to impeach a governor, but we should actually not find it pleasant that we impeach governors regularly. Because if we found it pleasant as a country, it will also put to question our own sense of judgment as electors. If after every election, the people we elect invariably are removed, then it means we are electing only gross violators of the Constitution. Only people who grossly misconduct themselves.
We should
What
impeach
does
ourselves.
that say about ourselves, as it were?
Yeah.
So it should not be something very pleasant that we invariably impeach governors.
Keep doing.
Yes.
Then I want to actually roll on to that with the following question. Using the case of Governor Wambora and now what is unfolding about Governor Kawira Mwangaza, should we say if a county assembly impeaches a governor after X number of times, go back to the people, dissolve this county government, both the executive and the assembly, take the matter back to the sovereign?
Our law says that when you elect a governor as an electorate, remember that the person he or she has appointed, nominated as a running mate is a potential governor. So that must be an important part of what is weighing in your mind as you make that decision. Over and above his programs for roads, for schools, for healthcare, also ask what is his potential success as you live up. Because you are electing as a package.
Yeah.
And the law says that if you remove that governor, then his running mate takes over. There's a procedure for getting a new deputy governor. When the person was initially elected, deputy governor assumes office. There's a procedure in law for that is provided for. So that's what we have today. Is it the best? It's debatable.
No, my
whether we
question
want to go back to the electorate, it's one of the choices we have. But let's us not cry that we are spending so much money on elections, because these things cut both ways.
True.
As citizens, we talk about waste all the time. So let's not, if we choose that as the option, let's remember it has a cost consequence. When IEBC comes and says we need 11 billion to do this election in this county, let's remember those are the choices we make. And no choice is free of cost. Every choice has either a value or monetary cost to it. And I therefore make no value choice myself. I say citizens just need to apply their mind and ask, are they willing to take the logical value or monetary consequences of the choice that they make?
Wakili, thank you very much for joining us. Isaac Babji says there's a mustache of wisdom in the studio this morning.
Thank you.
Elisha Ongoya is an advocate of the High Court of Kenya, a senior lecturer at the Kabarak University. He's a constitutional expert and he's been here giving us his own perspectives on impeachment laws, processes in this country. Come again soon, Wakili.
Thank you.
This is the Situation Room, the only way to start your day.